Hi, this is Rahul Reddy. We are here live from Houston, Texas. Along with me is my business partner, REDDY Neumann. We are in business from 1997. We do exclusively business immigration. Emily?
Thanks for joining us today. We're going to be talking a lot about recent trends with H-1B petitions, especially the topic of denials. We are seeing more and more denials every day, so we're going to talk about what happens in the event of a cap subject H-1B denial versus a denial of an extension, denial of a transfer, denial of an amendment. Hopefully we'll be able to also answer a lot of your questions, so please post your questions while we're talking here and we will get to as many as we can. If we're not able to get to your question for some reason, feel free to join one of our daily conference calls. We have it every day. You can come for free and dial in. The information is on our website at rnlawgroup.com. And if you want more specific information about your topic, you can always set up a consultation with us or any of our attorneys by going to rnlawgroup.com, and there's a button to push there for consultation. So when we're talking about all of these issues with H-1B denials, I just first want to point out that every case is different. Every case depends on the specific circumstances of the case. So for that reason, we would highly recommend that you contact an attorney, speak with the attorney who worked on your case or a different attorney to discuss all of your options related to what you can do with the H-1B denial. We're here to provide more general information based on information that most people might need to know, but because a denial is such an important situation, we would definitely recommend that you speak with an attorney for your specific case.
Emily, now since the denials are very heavy, and we have advised people that they should be contacting a lawyer under all circumstances so that they can get the things done. Now, what are the situations where there are different situations? There are 3 or 4 different situations the H-1B can be denied. Let's speak of the situation where the H-1B has been denied in the quota cases. Mm-hmm. And in the quota cases, there are 3 or 4 different scenarios where the H-1B can be denied. So if the H-1B is denied while the cap has expired, as you remember that, the cap is that it allows the people to work while the H-1B is pending until September 30th, mm-hmm. and they should stop working. And now the cap has expired, the H-1B is denied. What are the options for those people?
Yeah, so it depends on 2 issues. Number 1 is when was the H-1B denied? So as you mentioned, the cap gap ended on September 30th. For those that remained in the U.S. beyond that date, you started your 60-day grace period from October 1st. That 60-day grace period ended on November 29th. So if your denial occurred between October 1st and November 29th, you may have the possibility of continuing your F1 status because you have not completed F1 yet. You're still in the grace period. If the denial occurred after November 29th, your F1 status has now expired because the grace period ended, and the denial puts you out of status unless you've done something else to continue to maintain your status. So again, because there's so many different scenarios, we would definitely recommend that you contact an attorney to discuss your specific case. But in the event of one of these denials, you need to first figure out how it impacts your status. Does your underlying status continue? We are seeing some denials of F1 status that mention a violation of F1 status, particularly in the situation of CPT in a second degree program or in STEM OPT where the STEM training plan was not complied with. USCIS has sometimes been denying the petition as well as the change of status on the grounds of a status violation, and those are even more important to talk to an attorney about because that means you're no longer in F1 status And under the August 9th memo on unlawful presence for F1 students, it means you're accruing unlawful presence, possibly from August 9th. You have to make sure you do not exceed 180 days of unlawful presence. So what options do you have if a denial occurs on a CAP petition? So, a lot of times in a denial situation, refiling can be a good option. Here you don't have that option. The only way you can refile a CAP petition is to wait until April and file it again and hope that you make it through the lottery again. So because the petition was denied, you're not counted in the CAP anymore, and you're going to have to go through the lottery again. So because of that, you may want to consider filing an appeal or a motion to reopen or motion to reconsider. All of those really depend on the facts of the case, but those filings have to be done within 30 days of the denial.
Emily, in the situations where the H-1B has been denied from CAP to the H-1B, in the situations where it has been denied from STEM extension to the H-1B, is the denials are not only coming about the H-1Bs, but they're also coming with the status denials. And with the status denials, you know that the August 9th memo will go back and say that if they violated the status from before August 9th, that means that they are accumulating the unlawful presence. So what is your advice in there? I mean, I know that you told me to contact. What is the solution for these people?
Yeah, one important thing to be aware of is an appeal or a motion does not keep you in status. It does not stop unlawful presence unless the motion is successful. And the problem is the processing times of the motion or the appeal can sometimes be more than 6 months. And while you're waiting for it, if it's ultimately not successful, you'll be accruing unlawful presence the whole time. We've been talking about February being a very important date due to the August 9th memo, because we want to make sure that from August 9th, you're not exceeding 180 days of unlawful presence, which is early February. So it may be necessary for you to exit the country before February in order to ensure that you're not going to trigger that 3-year bar that we've been talking about.
And Emily, in the extension case of the denial, we're going to cover more extensively too. If the H-1B extension has been filed and the extension has been denied, in situations where the I-94 is still valid, where the extension has been denied, I-94, what are the options available for the individuals in those situations?
Okay, so that's a little bit better situation because the underlying petition has not yet expired. You're allowed to continue to remain in the U.S. and continue to work for that employer until your I-94 expires. So if there's enough time, that may give you the option of actually refiling your extension if you can overcome the grounds for denial and then continue to maintain your status. So that's kind of why we've talked a lot about filing early for your extension. When premium is available, we recommend filing and premium processing so that if something goes wrong, it happens early enough to where you can make modifications and refile, or maybe file a transfer to another employer, or even file a change of status to a different type of visa if you might qualify for that. All of those things can be done in the event that a denial occurs before your I-94 has expired. In
the same scenario, when the I-94 expired, what are the options at that point of time?
Not a lot. The I-94 expiration means that on the day following the denial, you're accruing unlawful presence. You're out of status from that date and accruing unlawful presence. And it's not really that easy to get back into status or stop accruing unlawful presence unless you've filed an appeal and again, it's ultimately successful. But the amount of time you have to wait for that to be successful, you might end up exceeding 180 days of unlawful presence while you're waiting. So that is a very big risk. So for that reason, you may have to exit the country while you come up with Plan B in that situation.
Emily, in the situation where the person has applied for the transfer of the H-1B from company A to company B, and the I-94 for the previous company's H-1B has not been expired, what is the situation in that case?
Well, in the event that the transfer is denied, the denial puts you out of status, but there's no unlawful presence because the I-94 has not expired yet. And there is a provision, kind of a USCIS guidance or an old INS guidance called dormant H-1B that says that your previous petition that has not expired remains valid unless that company has withdrawn it or it's been revoked. So in this situation, it may be possible to go back to the prior employer to get back into H-1B status and continue even if a transfer has been denied.
Emily, can they refile the transfer?
Potentially, especially if you're able to go back to the previous company to maintain your status and then refile, that is an option. You may refile requesting consular processing so that once it's approved, you can, if necessary, get the visa stamp and come back in to regain your H-1B status. So there are various options available, but it really is dependent on the specific situation.
Emily, what are the situations where the amendment of the H-1B has been denied? What are the options available at that point of time?
Again, there's not a lot of guidance on what a denial of an amendment means. And so I tend to treat it the same way as the denial of a transfer and the idea of this dormant H-1B. The underlying petition that's already been approved remains valid. It was just the amendment portion that was denied. So if you can go back to the terms and conditions of the underlying petition that's still approved, then you can continue your status that way, and potentially, if you think you can overcome the grounds of the denial, refile the amendment to continue your status.
Emily, in the April 2019 H-1B quota, there are new regulations that were being published. How is this lottery system under the proposed regulations is going to work out? What should the employers and employees be careful in doing it?
So the proposal, again, this is just a proposal right now, but the USCIS director has made it clear that they want this to be implemented for the April 2019 lottery. So the plan is an electronic pre-registration filing system. So sometime in potentially mid-March, they will open up a 2-week window that allows an employer to go onto the USCIS website and register for the petitions they plan on filing in the lottery. So the employer would provide their company name, their tax ID number, the beneficiary name, the beneficiary's passport information, date of birth, just basic information like that, and then whether they're intending to file in the advanced degree cap or the regular cap. During that 2-week window, they'll gather all of these registrations, and then they'll run the lottery based on that. Once you're selected based on the electronic lottery, you'll get a notification telling you you've been selected. Now you can file your H-1B petition. So everything up till this point is done electronically. There's no LCA involved yet. You're just letting them know that you intend to file for a particular person, and then if selected, at that point you start preparing your filing. And they'll give you a 60-day filing window, either from April 1st to May 30th or May 1st to June 30th. They're staggering them so that they can more efficiently receive all of the petitions that were selected. So from that point, you'll get your receipt notice and it'll be processed as normal. The other change to the lottery is they're going to reverse the order that they're doing the lotteries in. So there are 2 parts to the H-1B lottery. There's the master's cap where they select 20,000, and then there's the bachelor's cap where those that are non-US masters receive the remaining 85,000. Or 65,000, sorry. So what they do right now is they put all of the master's cap applicants in one pool and select 20,000 approximately. They actually select more because they know a certain number will be denied or rejected or withdrawn for whatever reason later. So they're going to accept approximately 20,000. And then those that weren't selected in that master's cap, they put in a pool in the regular cap and they run the lottery for the remaining number. Now what they're proposing to do is put everybody in the regular lottery, pull the 65,000, and then the master's cap applicants that weren't selected, they'll do another lottery of just those to pull another 20,000. Supposedly, based on the numbers, they think that will increase the chances of a U.S. master's applicant getting selected by about 16%. So that, of course, that means those that do not have a U.S. master's degree are going to have a lower chance of selection in the lottery if this change goes through. There's a comment period that just opened. We have until January 2nd to submit comments on that, and anyone in the public can do so, and then they'll decide if they're going to go forward with this. So this might be a very last-minute preparation in order to get ready for the lottery this year.
Okay. Emily, we're going to go to the live questions here. One of the questions that came from Mehul is that, can you transfer from EB2 to F2B category? He meant to say that whether he can transfer from employment-based immigration to the family-based immigration. So no, you cannot transfer from employment-based 2 criteria to the family-based criteria. You cannot do that thing. Another question that came out is that my OPT expired in January 2018, H-1B denied, what to do? Emily?
The OPT expired in when?
January 2018.
Okay, and so I guess it depends on what the status was at the time of filing in April.
Right.
Because the cap gap wouldn't apply in that situation.
That's right, cap gap is not there for him.
Yeah, so it depends on if this person has continued to maintain F1 status or some other underlying status while the H-1B was in process, or if not, then they don't have any underlying status to revert back to. So they definitely should discuss with an attorney.
Is going for a H4 to F1 to Canada, H4 to F1 to Canada advisable? No, we don't advise people to go to Canada from H4 to F1. If you were to do it, I would recommend that you actually go to your home country. As such, we have noticed a lot of denials that are coming from H4 to F1 when they go for stamping in India. The main reason why the H4 to H1 is H4 to F1 is getting denied is that for F1 you must have an intention of temporarily staying in the United States. And when they see that you have been here for a while, either on H-1B or H-4, when you go there telling that I've been there for a while, now I'm coming back, I'm going to only go there for applying for F1, they don't trust that you're going to come back to your home country. That's the reason where we see a lot of denials. Any other?
So I talked a little bit about this new lottery system that's, again, it's just a proposal, but it seems pretty likely it'll be in play. What do you think are the ultimate implications of this? Do you think that there's going to be a lot of people that register compared to filings in the past?
Since the enforcement of those people who are going to be filing duplicate applications is very much Emily, I hope so that this might avoid the duplicate applications. The reason is that they're asking the name of the individual, the date of birth, and the passport number. So if there is any duplicate applications there, they might weed away. And they were not doing as much before. Hopefully, so this new application system might weed away the duplicate filing. So that might be beneficial for a lot of people. As you explained, the master's quota has a better chance of getting the approval. That's good for a lot of those people who are doing master's degree here and wanting to apply for the H-1B. They have a better chance. Emily, can you please, Karma is asking the question, can you please touch base on what is going on the H-4 EAD?
Yeah, I checked today and still the proposed rule has not been submitted to OMB for their initial review before it can be published. So that means that it doesn't seem that likely that we'll see it by the end of the year, but we still expect that it is coming. So just know that at some point there will be a regulation proposed to rescind the H-4 EAD. We'll have a 60-day, most likely, comment period on that, and then they'll have to review all of those comments before they can come up with a final rule and make a final decision about whether to rescind it or not. It's going very slowly, which is very common for these regulations. They often get delayed.
What are the probabilities that the new regulation, proposed regulations for the April 2019 to be implemented in the April 2019? They put a clause saying that we may delay it, is that right, in the proposed regulations?
Yeah, I think it is going to depend on whether they have the system up and running in time and don't have any technical difficulties. These days with all of the electronic systems, I am concerned that they're going to open up that 2-week window and there's just going to be so many people logging in, it's going to crash the system. So there's a chance that there is a specific provision in the proposal that allows them to suspend the electronic system and then go back to the old way due to technical difficulties.
I have a question from Sunkara. He has an EB2 to EB3 filing concurrently for 485. Can you file I-140 in premium processing when you're filing EB2 to EB3? We do not, since you do not have the labor certification original because you filed it with the EB2 application, I'm assuming that you're converting from EB2 to EB3 and you don't have the original labor certification. I do not recommend that you file in premium processing. Because what happens when they don't see the labor certification original, they might deny the entire I-140, and if they do that, reject, not deny. If they do that, they might send your 485 application back. So when you file an EB2 to EB3 conversion, what I would recommend is to file under the normal processing, get the receipt notice for the EB3, then convert into then convert into premium processing. In that way, you're not risking your I-140 to be summarily rejected. If you do in this fashion, at the most, they might reject the premium processing, which is not a big deal. At least your 485 application isn't there.
All right, Krishna has a question about what happens if an amendment gets denied and the underlying approval has been withdrawn. Will I still be cap exempt in the future? And that's a good question. So generally the answer is going to be yes. Once you've been counted in the cap and you've actually used some of your H-1B time, you can recapture the remaining portion of your 6-year limit at any time in the future without going through the lottery again. There are certain exceptions to that, particularly if the underlying petition was the first petition that was approved and maybe it was revoked due to some misrepresentation or some problem in the filing. That could make you no longer counted. But if you've been in H-1B status for some time and the amendment was simply withdrawn because you're no longer working at that particular company and under those terms and conditions, you should be cap exempt in the future.
Abhishek has this question, what do we expect EB1C priority date? There is no EB1C priority date. All EB1s are the same, but of course EB1C comes under that. I'm not expecting much movement in EB1 at this point of time though. You may have to wait a couple of months to see if there is going to be any movement. Because of the number of applications that are coming for those people who are born in India, there is going to be a significant backlog in EB1 category also.
Jessica has a question. She had applied for a change of status from F1 to TN, which is for Mexican or Canadian citizens, and instead decided to exit the country because it was taking too long and now wants to apply for a new F1 visa. Are there any issues with getting the F1 visa? Potentially, yes. So when you're applying for your F1 visa, you still have to prove that you have non-immigrant intent and that the purpose of your visit or your stay in the U.S. is to study and that you intend to return to your home country at the end of your program. And having that filed and still pending application for a work visa may suggest otherwise to the consular officer. So definitely you'll need to have enough documentation to prove that you meet all of those requirements. Now the change of status to TN could have been filed in premium processing where the approval could have been issued in just a couple of weeks. So I'm not sure why it was waiting so long. You could still upgrade, but at this point, the change of status is going to be automatically abandoned since you've left the country.
Sakshi has this question. Does the change of status from STEM extension to H-1B denial has any impact? There is a good chance that it may have an impact. There are two ways the H-1Bs are getting rejected right now. One way of getting rejection is that they just simply reject the H-1B, and if they do that, it won't have any impact on your STEM extension or on the OPT. But if they deny the H-1B and they further comment that you did violated the STEM extension or OPT, that creates a problem. Now, previous to this, previous to 3 months before, I mean, from the time in 1997 that I've been practicing, 1995, I've been practicing all the way to 2017, we never saw the H-1B denial plus the change of status denial. We only saw the H-1B denial. But we are noticing a significant H-1B denial along with the change of status denial. And if the change of status is denied, it's going to affect your STEM extension or your OPT. That's the reason why we initially said that if you have a H-1B denial, it is very important that you contact a lawyer, make sure that you show him the entire denial. Sometimes the denial is coming in one denial. Sometimes the denial is coming in two separate denials. One denial is for the H-1B, one denial is for the status. So it's better that you evaluate your denial by a competent lawyer before you make any decisions, because otherwise you might be in great trouble.
Srinivas has a question regarding the 6-year limit for H-1Bs and labor certification that's in process. So the labor certification hasn't been filed yet. It's in the process to be filed, but he's getting close to the 6-year limit on H-1B and wants to know what options are there. So first, I would recommend verifying that you are correct in your calculation of the 6-year limit. Make sure that you've recaptured all time that you've spent outside the U.S. to make sure that you've got that correct date. As far as what options you have, there is no way to speed up a labor certification. There's no expedite, it's first in, first out, there's no premium processing. So if the labor certification is not approved to where you can get your I-140 filed and approved in time, you may need to take a planned vacation for a little while in order to be able to later recapture enough time to get you to when your I-140 is approved. Or if that's not possible, exit the country when you're right before you complete your 6-year limit and wait outside the U.S. until your I-140 is approved, then file the H-1B petition for consular processing requesting 3 years under AC-21 and then come back.
A question that I have from Mahajan is that, are there any updates on HR 392? Unfortunately, no updates. Now, we call this as a lame duck session. What does that mean is the new Congress is going to come in January. The old Congress is going to stay until December 31st. So, in this lame duck session, we are not expecting any miracles with regards to the HR 390. It's not in the top of their agenda right now.
Mahalakshmi has a question about the SOC code for computer systems analysts 151121 for H-1Bs. Should this one be avoided altogether, or are there sometimes it's a good code to use? It really depends on the job, and it depends on several other factors, particularly the wage level. The higher the wage level, the easier it is to prove specialty occupation. And he mentions that there are certain positions that fall under that general code that do always require a bachelor's degree in a specific field. So it's difficult to rely on the Occupational Outlook Handbook, which is used under one of the first criteria for proving specialty occupation, because the wording of the Occupational Outlook Handbook makes it sound like not all computer systems analysts need to have that degree. So you may have to rely on the second and fourth prongs of specialty occupation, which involve explaining how this position is more unique and complex, or how it is more complicated and more technical and therefore requires a degree when other computer systems analyst positions might not. It also can be very helpful if the employer has a past track record of hiring only people with that degree for that particular position. When submitting documentation about past employment practices, USCIS goes through it with a fine-tooth comb. They want to know exactly how many people they've hired in the past in this position. Are the two positions truly the same? And then make sure that you have the education documents and pay records to prove that they've actually hired those individuals. So it's not impossible to get an approval under that code, but definitely expect a request for evidence.
Emily, I'm getting a lot of questions on the CPT issues. I want your attention on these things. Rakesh is asking this question: what will happen to those people who have been continuously on CPT for 2 or 3 years?
Well, as of right now, they haven't yet crossed 180 days. When we do get
what
past
do you
that
mean by
point,
they didn't cross 180 days? They were here on CPT for past 2 years.
right, so the August 9th memo only takes effect from August 9th. So even if USCIS determines that the whole CPT time was a violation of status, because the memo wasn't in existence until August 9th, unlawful presence will still only begin from August 9th. But starting in February, that's when we're going to start seeing the real impact to those that have used this CPT and are receiving a denial of a change of status because of that status violation. They're going to be triggering that 3-year bar, and a lot of them won't even realize it until it's too late.
Another question is coming from Mahi. I'm on the second master's in CPT and H-1B transfer is pending. Can I travel to India? Do you have to wait until the H-1B result? It's a very tough question to answer. One of the things is that, as Emily pointed out, if you are on CPT, we know these CPTs, these universities don't conduct any classes. They conduct, if ever they conduct any classes, that's once in a month or once in a semester. So that doesn't look to be a genuine universities according to us. If you are in one of those universities which you are on CPT, you may want to consult a lawyer immediately, because you need to be worried about the 3-year and 10-year bar. As Emily has pointed out, once you hit the February 4th, you might be at a point of no return. You will be squeezed up, you will be holed up, and there might not be much options. If you are on CPT, anybody who is on the day 1 CPT, now you guys know what I mean by day 1 CPTs. If you guys are, you need to check with the articles that we have written, the 180-day rule and 365-day rule and the August 9th memo and the 3 and 10-year bar. Because once you hit February, that is a point of no return. You might have to take an action way before February. It's better that you consult a lawyer to make your decision, because most of these people will be ruled to be unlawfully present, and that is going to affect them a lifelong for a lot of people. It will be 3-year bar initially, and you continue to stay for 365 days starting from August 9th of 2018. You will hit a 10-year bar, so that is not what you want to do.
All right, Preeti asks if it's easier to get an H-1B for those having a master's degree from the U.S. So the master's degree comes into play in 2 areas. Number 1, it does give you an advantage in being selected in the lottery if it's a U.S. degree that qualifies under the master's cap. And number 2, if you have a U.S. degree that's in the field that's needed by your position, it's much easier to show that you meet the education requirements for the position. You don't have to worry about getting an education evaluation for that. So for those 2 reasons, yes, it does make it a little bit easier to get into the lottery and potentially get an approval, but everything, all the requirements of the H-1B still have to be met. You still have to have an employer-employee relationship, still has to be a specialty occupation position. So all the same requests for evidence issues can still come up even if you have a U.S. degree.
Ranganath has this question for you, Emily. You're a good person to answer this question. It's very tough for me. From YouTube, his question is that, is there any special reason why the USCIS has given me a 1-month H-1B?
For an extension, I assume?
Yes, I guess.
Yeah, so we're seeing this as well, and it typically comes up in the situation involving third-party placement, where you're working for a company that's placing you at the site of another company to complete a specific project. And normally in that situation, the project documentation has to be submitted to USCIS so that they can verify that there's sufficient work available for you. Now, those project documents typically include a letter from the client where you're working, where you're placed at, as well as the contract and work order between the client and your H-1B sponsoring company. Many times we find that these work orders are expiring at inopportune times. When you're trying to file your 3-year extension request, you might have a work order that expires a month from now. And that doesn't mean that the project is ending a month from now. That's how the budget process works for these big companies, and they continually renew the work orders. USCIS doesn't understand that, and so whatever date is given as an end date on the work order or end client letter, they might give you that date on your extension, unfortunately. There's not a lot that can be done to avoid it if that's the date. And there is a lawsuit going on that exact issue right now, but all of that's still up in the air.
Anil has this question. I forgot to apply for the H-4 visa for my spouse, and my H-1B is approved. How long can they stay here? I would recommend that your spouse leaves the country immediately and goes and applies for the H-4 visa in your home country, because you may be you may be violating the status, and it's not advisable. F2 is no longer valid since your H-1B is approved, so you need to take immediate action. The faster that you take an action, the better you would be in.
Karthik has a question about an H-1 transfer in a situation where his current employment is ending, let's say December 25th, but the new employment won't begin until January 5th. Is there going to be a problem with that gap? Generally, under the January 17th, 2017 regulation that created the 60-day grace period, you should be able to avail yourself of that to show that you've maintained your status the entire time, because you're filing that transfer within 60 days of when employment ended with the first company.
Sai Kishore has this question from Facebook. An individual under MAVNI program in process, can employer be applied process a GC application? Sai, if you are under the MAVNI program, which is the program for individuals who want to join the armed forces of the United States. Armed forces doesn't mean all the time combat forces. There are other subsidiary forces too. This program has been kind of scrapped more or less. There's very limited opportunities there right now. I'm assuming that you are maintaining your legal status on whatever legal status you are in, because you are expecting to become a U.S. citizen directly without getting the green card, which, that's provision is there for MAVNI program. But while that process is going on, and if you are maintaining the non-immigrant process, nothing is prohibiting your company to file for the green card application. So if you're an H-1B program and then you applied for MAVNI and it's still in the process, you haven't got the citizenship, and if you're applying for a green card process with company A or company B, it doesn't matter. It's not in conflict with MAVNI. You're good to do that thing.
Sohrav has a question about the transition from F1 to H1, as well as the transition for his spouse from F2 to H4. So the F2 to H4 was filed later than the F1 to H1. Now it's still pending, but the H-1B got approved. Does that cause any problems for his spouse? And the answer is no, because her change of status was filed while yours was still pending. From the day your H-1 is approved, she's no longer in F2 status, but she is in a period of authorized stay based on the pending change of status, and that will continue until the change of status is ultimately approved. So she can remain in the U.S. while she waits for that.
I don't like this guy's name, but I will answer this guy's question. His question is very good. He put his name as KKK. Of course, I don't like that. Just get the what is meaning of KK. You'll understand why I don't like that one. But anyway, that's more racial thing. That's the reason I was. How many how many days can you have a gap between company A and company B? Can I have a gap of 1 week in joining from company A to company B on H-1B? KK, I would just address KK with you. Now, if you have the I-94 valid, that is the crucial point here. You're telling that you're going to leave the company A on December 25th. You're going to join the company B on January 2nd. I don't have a problem with that as long as your I-94 with company A is valid beyond January 2nd of 2019. Now, the January 17, 2017 new regulations were being passed wherein they allowed people, when they are changing companies from A to B, they are allowed to have a gap of up to 60 days. Since 7 days falls under 60 days, you're good, but your I-94 validity should be there.
Vinod has a question. His H-1 extension got approved in premium, but his dependent's H-4 is still pending. Are we seeing that where they get separated? Yes, that did happen previously when the premium processing suspension was going on. We saw, especially in Nebraska, they were approving the H-1s, but then the H-4s were kind of set aside and adjudicated later. They were still faster than the regular H-4 processing time, but yes, we are seeing some delays from that. That is common.
Ankita Sharma got her H-1B denied because it was under the SOC code of Operation Research Analyst. And now she's considering filing again in this year. What should she be? Here is the issue with the Operations Research Analyst. The H-1B position must require a specific degree as a requirement. Operation Research Analyst is kind of very broader thing. It could be in many different ways that Operation Research Analyst can be put it in. So I'm not that comfortable with that title. I would, if I'm a lawyer for you, I would sit down with you and I would sit down with your employer, looking at the requirements of what the employer, what the company does, looking at what your education requirement are. Probably if it suits the employer and if it suits the employee, and an alternative title would be much better than Operation Research Analyst.
Along those same lines, Sai has a question. He's got a computer science degree. Will an LCA with the SOC code of Computer Systems Analyst have a potential of a specialty occupation issue? Yes. The Computer Science Analyst Occupational Outlook Handbook is not that helpful to prove specialty occupation, and we see a lot of requests for evidence using that code. If it might fall under a different category might be a better option that has a higher chance of success. Shravan asks, does an H-1B job have to be full-time? No, you can actually be sponsored for a part-time H-1B. You have to specify the number of hours per week in that petition, and USCIS will, obviously the number of hours could be an issue if it's so low that you're not making enough money to support yourself. That could be a problem, but generally, yes, you can file a part-time H-1B.
Rajesh has this question. He was an L-1B for 3 years, moved to his home country and came back within 9 months on a H-1B. Will his 3 years of L-1B count towards the 6 years of H-1B? The answer is clearly yes. One reason is that you didn't stay for 1 year period outside the country. That's the reason why your 3 years will be counted. Lots of questions coming up. Can a H-1B employee start a startup company? No. You cannot start a startup company. No, sir.
Purva asks about doing an externship while on F1. Do I need a CPT for the same? Generally, yes. Generally, any kind of employment or internship that is not on campus is going to require CPT to do that. But definitely check with your DSO on that, on the specifics of that program.
H4 to F1B visa has been H4 to F1 visa has been denied. Can I come back on the H4? No. Once your visa has been denied, you should reapply for the H4 visa, because if the F1 is not denied, it's a different situation. If the F1 is approved, you could have come back on H4 or F1, but if it's been denied, you need to reapply for the H4 visa to come in. Sandeep has this question: how long it's taking for the I-140 processing right now? It's taking about 6 to 9 months for the I-140 processing. But luckily you do have a premium processing for the I-140. You may want to use that.
Jayanch asks, he has a valid H-1 until 2022. Can he travel to his home country for stamping? There's a lot of factors that go into answering that question. Depends on the strength of the H-1B petition, what kind of company it is, what kind of job it is, do you have all the pay statements? Just not enough information to be able to answer that. In general, stamping is not an easy process. Just because you got the petition approved does not mean you'll get the visa stamped. So definitely speak with a lawyer before you make any travel plans to make sure you don't get stuck.
Manish Kumar has this question: I moved from company A to company B full-time with a receipt. What are my options if the H-1B gets denied? You may want to contact the lawyer, because you said that your I-94 validity period is still there with company A, and then you move to company B gets the transfer denied. There might be some option. There are some options available since you have the I-94 validity. There are some arguments that can be made that the 60-day period should start from the time of denial. But I want you to be very careful when you discuss these options with your employer. Please consult a lawyer because there are some caveats that you need to go through.
I guess we have time for one more question. This one is from Vishal. He has the opportunity to file his H-1 extension in premium at Nebraska. Do we recommend filing in premium, or should he do regular processing? Yes, file it in premium, especially.
What about the concept that if you file in premium, you'll get an RFE or you'll get a denial? Is that true, Emily?
I've not found that to be true, and honestly, if you're going to get an RFE in premium, it's because you would have gotten the same RFE in regular processing. I know there's a rumor out there that the officer just needs to buy more time, and so they're just issuing random RFEs. I see weird RFEs from time to time in premium, but the same weird RFEs happen from time to time in regular. It's not because you filed it in premium. I'm generally a big fan of premium processing. It just gives you the comfort of getting it done and over with, and if something goes wrong, you have the opportunity to fix it because your current status hasn't expired yet. It's just a much better situation to be in.
Potter has this question: I changed my employer, I'm eligible for the drop box. Is it safer to be in the drop box? I don't think so, because the Trump administration, nothing is safer right now. If you can avoid it, I would recommend it. Just because you're eligible for the drop box doesn't mean that everything is going to go through smoothly. We have noticed a significant number of people who are eligible for drop box who have been called for interview and then issued 221Gs. So I would be very cautious. Unless it's an emergency, I would not make a trip. Any other things, Emily?
I think that we have a lot of other questions, but we're running out of time.
Well, for those people whom we couldn't reach, please, you can always make an appointment with our office at any point of time, and you can go to rnlawgroup.com and make an appointment. We do have a daily conference call. You can go to rnlawgroup.com and you can find it. And what about your blog?
Yeah, if you visit immigrationgirl.com, you'll find the latest updates and different trends on what's going on. I answer a lot of questions there as well. And you can subscribe there so that when I post something, you'll get an email immediately and be up to date with all that's going on specifically in employment-based immigration.
Thank you guys for coming in. Thank you for joining.